trouble your lordship on one matter. A writ appeal, which was filed on 13th of October 2023. Uh, Two applications was filed along with appeal. One is the IA, leave to be granted. Another is condemnation of delay. Now that notice was issued in both the case. Appeal can be registered only when this your lordship allows. Now what has happened, my lord? This was an order passed by the learned single judge where we were not made a party. In our absence, my lord, the judgment was passed. That is why we filed an appeal. Now, what has happened, my lord? An eviction notice has been issued in respect of that judgment. Now, in that eviction notice, we are actually enjoying that particular we residing there. Now we file an writ petition against the eviction notice. There was an interim order, no coercive measure should be taken. So now the matter was listed twice or thrice. Then now the judgment of the learned single judge, now it stands against us. So we told the learned single judge that let this matter be sent to the division bench. I know, my lord, the learned single judge can't send it because the chief justice is a roster or master. So that is why we are praying, my lord. The matter can be listed on Monday, the writ appeal. Expired somewhere on for 17/11 because 17/11, I think. 4 weeks time was granted. So let it be listed, this appeal, my lord. Along with that, my lord, the writ petition may be tagged. We'll give the number. Otherwise, my lord, the learned single judge is finding it difficult. The judicial propriety demand that same order has to be passed. That demands. There's a learned single judge. We told the learned single yesterday it was listed. Again, it is going to be listed on Monday. I told the learned single judge, give me some time. I will just mention before the Honorable Chief Justice. Deeply obvious.
Lordship, item number 8, 9, and 10, Lordship. Lordship, with the consent of the other sides, Lordship, I am praying for 3 weeks' time, your Lordship. That Mizoram matter, Lordship, that medical. So we have been
taken the consent.
Yes,
Yes,
Lordship, the other side counsel is there, and I have taken. For 3 weeks' time, Lordship.
Met by Mr. A. Kalita, Learned Additional Advocate General Mizram. List the matter after 3 weeks.
3 weeks. Obliged.
May it please your lordship. My lord, a pending writ petition where my lord had issued notice on 15th of December, wherein the challenge was against the possession notice under SARFAESI Act in the presence of the bank's counsel. On 17th December, my lord, auction sale notice has been published in the local dailies. We have filed an IA. May I pray, my lord, this IA may be taken up either on 9th or 10th of January, my lord.
10th.
10th of January. Obliged.
May I please, sir? May I please, your lordship? I'd like to mention item number 3 of today's list.
Yes.
So, your lordship, in this case, I have been directed to file an affidavit, which require further 2-3 days time. So I pray for adjournment with the consent of the other side.
You have 40?
Respondent number 1, Indian Bank.
Where's Ganguly?
I am the for the petition.
Okay.
I have, is it there?
Otherwise, 1 minute, let it reach. It's in the, let it reach.
May it please your lordship. Lordship, I beg to mention one writ appeal, lordship. On third, I have moved this writ appeal, lordship. Your lordship has directed me to take step on the respondents, lordship. But the word admit or issue notice, those words are missing. So may I pray for listing of this matter on Monday, your lordship, for modification of that order? One of,
No, you'll have to file an IA.
lordship, the admit word is missing, lordship. It's a writ appeal and it was listed for admission column. And your
No, no,
lordship,
no.
after satisfying,
I remember that case. We did not admit it. We just issued notice.
but lordship, issue notice, that word is also not there, lordship. Only there is a direction for taking step, lordship.
Okay.
Maybe it is to be, and lordship, my one of the ground was that when the learned single judge called for the record, lordship, and without waiting for the record, the writ petition was disposed of. So I was under impression your lordship has admitted the appeal and thereafter called for.
No,
the-
no, it was not admitted.
In this case, lordship, the
We just
record.
said to take steps on the respondents.
Yes, lordship, issue notice, that word is missing.
Not necessary. Not necessary. There's already a direction to issue notice, to take
Lord, to
steps.
take step, lordship.
So that's all, not necessary for it.
Lordship.
You just take steps.
In fact, I was under impression your lordship has admitted and records
No.
were called for lordship.
It was not admitted.
Lordship. Obliged, lordship.
Maybe Lordship. Lordship, I beg to mention, IA4 my lord listing, it was filed on 22 December, my lord. It's for implement, my lord, that highway authority, my lord. That's fixed on 9th.
Fixed on
Fixed on
9th.
9th.
Okay.
May I praise you, Lordship?
Hmm.
Lordship, I beg to mention for listing on read appeal, Lordship.
Hmm.
Lordship, we have challenged the Honorable Single Judge order, Lordship. Matter is relating to the Lordship cancellation of allotment, Lordship, of flat, which was allotted under the Lordship Assam State Housing Board.
Hmm.
Lordship, eviction notice supposed to be issued, Lordship. So there is some urgency, Lordship. Can it be on Monday, Lordship?
Let it be on Tuesday.
Tuesday, Lordship. Obliged.
May please, my lord.
With the consent of the other side, I beg to mention item 32 and 33. One of the writ petitioners, that is the presently respondent, died. So we need to file substitution petition.
You are for the respondent.
Lordship, let's respondent.
You are mentioning on behalf of
I am A. Somua.
H. Amma.
A. Somua.
H.
A. Somua.
H.
Ashim Somua.
Okay, when do you want?
After 3 weeks, Lordship.
Okay, on request made by H. Amma, then the council for the respondent number
Only respondent,
for the respondents. List the matter after
3 weeks.
3 weeks.
Substitution petition need to be filed.
May please, my lord.
Hmm.
My lord, in item number 18, I appear for the respondent number 6. We have filed an affidavit in the matter that has not been tagged. It was just filed yesterday, ma'am.
Maybe one of us cannot take up this matter.
Perhaps, my lord.
Item 18. List this case before any other bench without one of us. You put within bracket Justice Kaushik Goswami.
Deeply obliged, my lord.
Lordship, with the consent of the other side, I beg to mention item number 34 of the daily list, Your Honor. Your Honor, Advocate D.N. Panda had to argue this case, Your Honor, but due to his ill health, Your Honor, he could not come to Guwahati. So only 4 weeks time may be given, Your Honor.
Body,
I am bringing for the petitioner, Your Honor, for D.N. Panda.
okay. On request made on behalf of Mr.
S.S. Gupta.
On request made by Mr. S.S. Gupta, learned counsel for the petitioner. List after
4 weeks, Your Honor.
4 weeks.
Okay. May I please, lordship?
Hmm.
With the due consent of the other side, lordship, I beg to mention item number 23, lord. In fact, I'm paying for adjournment, lordship.
These are all order matters. You are appearing for the
IHOE,
on request made on behalf of ISIKL and counsel for the applicant. List after
due vacation,
Hmm?
due vacation. Due vacation.
list on 24th.
Obliged.
Item 1 for motion.
Lordship, regarding issuance of IMFL wholesale warehouse license, my lord, in favor of private respondent. Now, my lord, petitioner has challenged the issuance, my lord, on the ground that there are objections from the local bodies, including the Panchayat president. Although, my lord, it is silent, my lord, 295 of the rule, my lord.
Give us the rule. What rule is it?
This
Some problem in this. Yeah, like,
But they, as I recall, my lords, last occasion, my lord, he was instructed to properly take instruction and read through the rule, my lords.
yes. What rule was it?
295 of Assam excise, my lords, Assam excise rules, man.
Assam access.
So it's regarding excise shop, but he is being aggrieved by opening of a, my lord, warehouse, my lord.
my lord, let me complete my submission, my lord. Thereafter, he will make
Two-
all sorts of.
two, my lord.
195,
95,
171
295.
page,
Rule?
Rule 295, my lord.
171 page.
Yes.
Now, my lord, on last occasion, it was pointed out that was regarding shops, my lord. Now, my lord, going by rule 294A, my lord. The shifting of premises license for wholesale or retail vend of foreign liquor, country spirit and heritage center from one location to another within the same district shall be allowed by excise on the prior approval of council. The shifting of premises to fulfill following condition that Cow Panchayat are concerned in whole area the premises license for and is proposed to be shifted has given no objection to that effect. Although there is no requirement, my lord, but in this provision, my lord, 294A, my lord, in case of shifting, my now, my lord, this may be taken into consideration, my lord. In my case, it is regarding issuance of fresh license, IMFL wholesale clients. But shifting, it is required,
Yours is a warehouse license.
my
is
lord,
it?
my lord. Similar in 294, in case of shifting, my lord,
Hmm.
objection from local bodies is required. Though there is no mention for issuance at the time of fresh issuance, whether it is required or not. Now, my lord, 295, there is requirement, my lord. 290 objection from local bodies to be considered, my lord. Now, 311, my lord, I can, it may help me, my lord, 311, my lord, page 175. Now, here shop is in the subterra, my lord. In this rule, there is anything dependent, the word shop and license shall be includes country spirit shops, Indian made foreign liquor shops, manufacturers, bonded warehouse, distilleries, breweries, and any other wholesale or retail license pass or permit granted under the provision of these rules. Now, my lord, going by this particular, my lord, provision, my lord, this shop, wholesale also comes, my lord.
Bonded warehouse.
My lord,
Yeah.
warehouse.
I am on a different thing of the matter, my lord. Though he has assailed this, my lord, I challenge his locus. My lord, there is a whisper, my lord, there is registered, but there is no whisper of registration details. And who is he, my lord? He just sentence is there that he is authorized. Where is the authority? And this organization is registered, my lord, because it is settled law, my lord, unregistered. It may be a my lord good cause. They cannot move the courts, my lord.
No,
I have
it is
a
a registered society.
No, my lord. It's only written, my lord. There is no substantiating materials, my lord. Where it is registered, who is he? No,
Are you a registered society?
Yes, my lord, I am a registered society
Where's the
under
registration?
society registration. My lord.
Where's your registration? Have you mentioned that in your PIL?
Yes, my lord, registered society I have mentioned, my lord.
There is no document annexed to it. And this is a
Registered society, my lord, registered under Society Registration Act 1860, my lord. In paragraph 1 of my petition.
the judgment, my lord, I have harping, my lord. This is also PIL. This is also PIL, my lord, moved by an NGO. In paragraph 6 and 8, my lord, it's clearly held out, my lord.
Where are your details of your registration? You can't just pass it. You'll have to mention it in your PIL.
My lord, it is a registered society, my lord, I have
You're registered society. Where are the details of your registered society? How do we know that yours is a registered society? Just making a statement won't do. You amend your PIL.
No, my lord, I'll file an additional affidavit to bring on record the addition in the form of additional affidavit, the registration certificate of my.
Okay, Mr.
J. Lashkar.
J. Laskarlani, counsel for the petitioner, is permitted to file an additional affidavit. Bring on record the details of the registration of the petitioner society. List after,
Well, let it be posted next week, my lord. Urgency is there.
we don't see any urgency. After Bihu,
All right, my lord.
The date may be
24th.
obliged.
Item 2.
Ramzan.
Yes.
The matter pertains to the illegal formation of the ବ୍ୟବহারকারী Parichalona Samiti of the Jal Jeevan Mission. It's a government scheme where the entire residents of the local Kodamani town were kept under complete darkness when the committee was formed. And moreover, your lordship, the employment also they has taken, the president's son has been selected, has been directly informed. So the same has been addressed to the deputy commissioner and also the, which is at page number 32, your lordship. And moreover, the chief executive engineer, public health engineering department was also given an intimation, page 35. But a letter was sent by the deputy commissioner to the member secretary in regards to the representation that was sent by the petitioners, which is at page 39 to the member secretary. But till date, no action has been taken in this regard. Our prayer is very simple. A committee may be formed under the proper guidance and the rules and regulations. Page 39 is the direction given by the deputy commissioner to the member secretary to make an investigation,
Hmm.
inquiry into the
What
matter.
happened after this?
Nothing has happened. And RTI also made no reply has been given till date.
Hmm. Which rules have been violated according to you?
Lordship, according to them, there is nothing has been informed to the common public, your lordship. They
No,
doesn't
on
know,
what basis?
lordship.
Are there any rules?
The rules are meant in the Jal Seva mission
What is
that
that rules?
has not been annexed here with the
How
rules.
do we know?
But the public has to be
Why
present
do
in
you file a defective PIL?
the lordship. No public has been informed about the,
Whatever it is that is there any rules saying that public has to be informed?
yes, lordship.
Where is that rule?
For the rules, your lordship, I may be allowed to file an additional affidavit, your lordship. This could not be annexed here.
How did you not annex? That is the basis on which your PIL will have to stand. Your PIL stands on the rules.
Yes.
How did you not annex it?
It could not be provided, your lordship, by the parties.
Let him withdraw it and file afresh. If we withdraw it and file a fresh PIL, we can't accept like
An additional affidavit may be allowed to be filed. Your Lordship.
not by way of in addition. Your whole basis is on the rules. That rules is not annexed. How do you allow you to file an additional affidavit? Either you amend your PIL or you withdraw and file a fresh PIL.
Lordship, I may be allowed to file, withdraw it.
Mr.
Yes, Ahmed.
S. Ahmed, learned counsel for the petitioner, prays for withdrawal of present PIL with liberty to file afresh. Mr.
D. Gogol for the PH.
Learned standing
Counsel.
counsel appears for the PhD department and MS
MD Bora for respondent number 4, the deputy
MP
counsel.
Bora, learned government advocate for the respondent. PIL is dismissed on withdrawal with liberty aspect.
Item 3.
Yeah. Here you wanted some time for filing your affidavit.
Yes.
On 13/12.
My lord, yes, sir, I have no objection. My lord. The matter may be fixed. The one of the manager is just transferred. And they have not filed affidavit today. And my lord, they may be filed affidavit and in compliance with the last order, my lord.
Have you
we-
deposited?
actually, we have.
Bounced, your lordship.
No, that is I'll have to submit to a document, my lord. Subsequently, it is he had sold a portion of land in Nalbari and that person had deposited in HDFC Bank. Under his instruction, he has deposited a check within 10 days, immediately before as per his instruction. And immediately, whenever the bank has informed the petitioner that it is due to insufficiency of fund, then he has informed the person concerned and he has deposited yesterday, my lord, through online 50,000 and today the balance amount will be deposited.
Last occasion, you said within 10 days.
Within that period, my lord, actually, I will have to collect. I being the cancer patient, he is not in a position to go to Nalbari, and that's why through telephonic miscommunication.
Mr. Sharma done a call.
On 19, I'll give you all in details, my lord.
Mr. M. Sharma,
Sharma, respondent.
standing
Yes, sir.
counsel
After Bihu, my lord. On
for the bank
But-
respondent. Grace, for how much time you want?
Your lordship, 1 week.
1 week time to be filed. After.
after Bihu, my lord.
Please, January.
My lord, date may be fixed, man.
25th.
20? Must be.
Item 4.
May I please, your lordship?
Yes.
So in this case, lordship, the petitioners are aggrieved by a letter dated 27/11/2023, annexure number 2, lordship, page number 21. Whereby the bank authority asks the petitioners to vacate their residential accommodation within 15 days from the date of receipt of the notice here. For non-payment
date
of
is
the
this?
housing loan, actually,
27/11.
yes, page number 21, lordship.
Hmm.
Actually, what happened, lordship, in the year 2015, the petitioners availed a housing loan for construction of a Assam type house in their land, lordship, from the respondent bank. The 15 lakhs rupees of loan was sanctioned. And due to some financial difficulties, they could not pay the loan amount regularly. But even then, lordship, if your lordship peruse page number 7, lordship, it starts from page number 5 itself. It's a details of the repayment, lordship. Out of 15 lakhs, I have already paid 12,73,668. And thereafter, the loan was declared as NPA, lordship, non-performing asset. And after declaration of the non-performing asset also, I have paid 2 lakh something rupees to the bank. And what happened, lordship, thereafter, the bank proceed as per law, as per SARFAESI, and thereafter they took the physical possession of the property. And lordship, on 27th of November, they issued this notice. Thereafter, what happened, lordship, me and my wife, petitioner, both her husband and wife, both approached to the bank and asked for a bank statement. What is the exact outstanding amount? So they furnish a copy of loan account statement, lordship. It is annexure number 1. Lordship will find from page number 15, annexure number 1. And if your lordship see page number 20, last page of the annexure number 1, lordship will find the total outstanding amount is 9,60,000 rupees. The total outstanding is due. But what happened? The bank authority informed us this is the amount which is shown in their books of account till the loan was declared as NPA. Thereafter, some additional interest amounts are also there. But we have no any idea about the additional interest. So therefore, we submitted a representation, lordship. Detailed representation before the authority on 16/12/2023, annexure number 3, lordship, page number 22. Where we have categorically stated and prayed before the authority, page number 27, last portion, lordship. If for a moment, if your lordship peruse page number 27, last portion. May I read, lordship? What is my prayer before the bank authority, actually? Therefore, we sincerely pray before your honor to look into the matter and consider our case in a sympathetic way, and after verification of records, may kindly provide us the exact outstanding loan amount, including the interest amount that is accumulated since 21/7/2019 till date, and thereafter may kindly intimate us what should be the exact amount is required to pay from our our behalf to regularize the loan account, and thereafter, what would be the monthly installment required to pay by us. Till date, the date of furnishing of the aforesaid information to us, we further request your authority not to take any coercive steps as mentioned in your earlier communication dated 21/11/2023 issued by on your bank. What happened? We are ready to pay the interest amount and to regularize the loan because the tenure is till 2035, Lordship. The loan was sanctioned in the year 2015 for 20 years. It will, if we paid regularly, then it will till 2035, Lordship. There is tenure, but due to non-payment from our side, that's why the loan was declared as NPA. So we want to reconstruct or regularize the loan. But if your bank authority inform us what should be the exact amount to pay, then we are ready to pay within a stipulated time. Within 3 months, we'll pay that amount, and thereafter we regularly pay the monthly installment, Lordship.
Yes, your lordship, we have taken action under SARFAESI Act, and the alternative efficacious remedy is before the Debts Recovery Tribunal. And their claim is that they have not been informed, but they have been informed. To upgrade the account, they required to pay 9,31,000, which they have not paid till date.
Have you informed them
Yes, yes,
on the basis of its representation?
yes, yes.
No,
Although we
have-
are not inclined to give the
When
representation.
did you inform them?
Yes, your lordship, it is,
We have no notice or no letter we have received.
This representation is 16/12/2023.
yes, thereafter on, we have given them on 28/12/2023, we required for upgradation of the account, rupees 9,31,000.
Where is that?
We have not received any.
Alternative for the remedies to affect.
And besides that, your lordship, this is an action under SARFAESI, and we are at the last stage.
Who is the date?
That it is below, your lordship.
Yes, come.
Monday khatte, no?
There's no date here.
Your lordship, in the last below line, it has been mentioned as 29/12.
29/12.
Yes, sir. For amount, for upgradation. Below the Excel sheet.
Hmm?
Below the Excel sheet, your lordship, that one chart has been prepared there.
Hmm.
Below.
No, no, no. There has to be a date on which you issued this letter.
Today morning, I talked to my client, Lordship, but no communication from the bank.
Please verify.
Yes, sir.
My only limited fear before your lordship is that my learned friend is correct. I am not disputing anything. They are proceed as per law. It is governed by SARFAESI. Everything is correct. I want to regularize my loan as per their interest. Whatever they want to impose the interest on us, we are ready to pay. The only thing is that this is the only residency recommendation to us for my entire family.
Don't you have a alternative remedy?
No. No, any other, we will be landless, Lordship, if they vacate from my residential accommodation. My parents, old parents
I'm
are there.
saying, don't you have an alternative remedy to approach?
No, Lordship, because
On the
only
basis of-
15 lakhs rupees is there, because if it is more than 20 lakhs, then DRT will. Now it is below 15,
It
10,
is 1
20
lakh.
lakhs.
DRT's jurisdiction is 1 lakh in SARFAESI matter.
Yes, 1 lakh.
It is
Give
in
us-
recovery of debts matter.
My
20
only
lakh.
prayer is that, Lordship, if this honorable court accommodate 3 months time, then I am ready to pay that amount, Lordship.
No.
And even within 3 days, I'll pay some amount to the bank, Lordship.
Which is that section?
13 to 51. 13(2) is the relevant section of SARFAESI, and 31 is the provisions.
13?
2. Yes, that is section 31H.
31H.
Yes.
1H.
Any security interest for securing repayment of any financial assets not exceed. That is SARFAESI.
31H.
H. Any security interest
31 sub close.
repayment of financial assets not exceeding 1 lakh.
Yes,
But in the 31 section, it is mentioned, Lordship, provision of this act not to apply in certain cases.
not to apply in certain cases. In certain cases, which it does not exceed 1 lakh.
1 lakh.
So in your case, it has to apply.
Then I'll approach before I approve it for the Lordship. Then until then, the coercive action may not be taken, Lordship, because
No, that we can approach. You approach the appropriate forum, then you get your interim order from them. So you want to withdraw this? Mister,
if you whatever.
then we come to petition, approach the withdrawal of this. With petition, with liberty to approach the appropriate forum. So, Mr. M.
And
Sharma, then
For 1 to 5.
counsel appears for the respondents 1 to 5. With petition is dismissed and withdrawal with liberty as spread for.
Item 5, implication of party.
Me, please, your lordships,
Mm.
because this application has been filed for implementing the home department as a respondent number 11. If my lords takes up page 15 of this application, this is the last order passed by your lordships in this matter, my lords. The lordships was of the opinion that the home department would be a necessary party herein. So accordingly, we have page 15, the order starts, the effective portion is at page 16, my lords.
Yes,
Lordship, I'm from health department. We have no objection.
you are appearing for?
Health department, Lord.
Health department. Any other respondents?
I'm earlier appeared for no 5 government of Assam. Only
I believe the government can accept notice for the home department.
Yes.
Okay, heard, Mr.
S. Vishwakarma.
It's Vishwakarman and a counsel for the applicant. Stop. Also heard, Mr.
Lordship, B. Gogol's name may be recorded.
B. Google and Assistant Council Health Department.
Lordship D.K. Boydha for respondent number 2, the National Medical Commission.
For the
Lordships, may I pray that the National Medical Commission may also be reflected as a party, my lord, in the
Okay,
instant
one-
matter, because it's not reflected.
National Medical Commission and MS RB Bora, Leonard Governor Advocate for the respondents. For the respondent number 5. Stop. By this application, the applicants are praying for improvement of Home and Political Department, Government of Assam, as respond number 11 in PIL number 34 of 2023. Stop. What is the reason shown?
The reasons shown is at paragraphs 3 and 4, my lords.
We have Pirus, para 3 and 4 of the present application. And we are satisfied with the post. And accordingly, the prayer for improvement is allowed. IS. In the main PIL, you write. You have the order passed the date now, so and so, I number so and so. Let the Home and Political Department, Government of Assam, be included as party respondent number 11. Stop. MS RV Bora, Leonard Government Advocate, and this appearance on behalf of the newly inflated respond number 11. As such, no further steps are required. However, extra copies will be furnished to the Leonard Government Advocate within the course of the day.
Yes, ma'am.
Within the course of the day. So, petitioners are also directed to file an amended course title within
3 days, my lords.
within 3 days. Stop. List after 2 weeks.
Yeah, yes, my
2
lords.
weeks.
Item 6 for admission.
This particular matter on this subject, we are holding some meetings with the department, trying to find out if we can get a solution to it. Last meeting was held on 22nd, madam, and another is scheduled for the immediately after the Bihu matter on 19th. The matter will be taken up thereafter, my lord, if we can come to a solution. Matter is regarding the pay scale.
But Mr. Deepak is still responsible for the applicants. On request made by R. Majumdar, Learned Standing Council, School Education Department. Reach the matter when
My lord, let it be in the last week of January, madam, 29th or 30th.
29.
My lord. Obliged.
Item 7. My lord, there is a limit of defiance of the honorable court direction, and my lord, the appellant before lordship is a retired employee who was retired in the year 2015. He is fighting for his dues amount as much as for my lord current pension benefit. Once it was not my lord received, this honorable court fight order dated 17/10/2023. Lordship, kindly have a look. 17/10/2023.
Lordship, current
Lordship,
pension
let
has
me
been
complete,
provided,
my lord. Let me complete, my lord. It's not that thing that they can jump this way, my lord. Whenever this matter listed, my lord, they take excuses, my lord. This is not that kind of case. Lordship, 17/10/2023. Lordship, kindly allow me to read. Mr. D. Mojumdar, Learned Additional Advocate General, Assam, submits that 21 other retired employees of the Golpa Municipal Board have approached this court seeking direction similar to what the appellant seek in this writ appeal. However, on instruction from Mrs. Kalyani Kankana Das, ADC cum Chief Executive Officer of the Golpa Municipal Board, and Mr. Mahendra Pathak, Chairperson of the Golpa Municipal Board, present in the court, Mr. Majumdar assured that the current pension as per the retirement shall be paid to the appellant from now onwards. Regarding the area, the matter still remain under consideration. Therefore, Lordship, this order reflects that from the month of October, this order is enforceable. No payment was made. Again, this honorable court took up this matter on 13/12/2023. They made another excuses that the chairman was under medical treatment, therefore they need 1 week time. Till that, my lord, no payment has been made. My lord, my lordship, my prayer is that, my lord, that their attitude is very important. It is not a case singular, my lord, that other persons are being affected. Lordship may issue arrest of warrant against them, and my lord, take necessary action, because this kind of thing they cannot do, my lord.
Lordship, payment has been, there one.
Have you made the payment last occasion?
Yes,
You said
Lordship.
within 1 week.
To Lordship's order, Lordship, up to December, from October, Lordship has passed the order. And thereafter, we have already paid up till December, Lordship.
My lord,
January
till
is due.
yesterday, I have not received, my lord. My instruction. is that.
Lordship, this is there, Lordship.
Have you given him a copy?
And Lordship, right now I don't have, I can forward it to him.
Lord,
He
they
can
can-
take instruction on this, Lordship.
My lord, if I would receive the payment, my lord, I am the first person to know that I have received the payment. Till
Octo-
yesterday, I have not received my payment.
October, November, Lordship, the check dated 22/12, and Lordship for December, it is 3/1, Lordship.
My lord, they are playing with the honorable court direction, my lord. It's a very straight case, my lord. They are playing with, my lord, the rights of a, my lord, a retired person, my lord. My lord, I have not received, my lord. Yesterday, I have communicated with my client. He's saying that he has not received, my lord.
Have you given the check?
Lordship, this is check.
Issuance of a check is a different thing. Handing
Lordship.
over the check to the petitioner is
Lordship,
another
that
thing.
instruction, Lordship, may kindly take after sometime. I'll just take the telephone
Okay.
and appraise your Lordship.
Otherwise, my
This
lord,
has been debited
suppose
or
they fail
taken
to
over,
comply with
Lordship.
the order, my lord, arrest of warrant may be issued, my lord. Let them learn a lesson, my lord.
Lordship, after 5 minutes, Lordship, I'm just.
It's a matter of, my lord, judicial discipline.
Item 11.
Me, please, my lord. The respondents were to file an affidavit, your lordship, but that has not been filed yet.
Who are the respondents?
Social Justice and Empowerment Department, your lordship. Then the Director of Tribal Affairs, the Assam Backward Classes Commission.
Yes.
In this, similar matters are pending, Lordship. This matter also may be tagged.
Similar matters may be pending, but then last occasion we give you time to file your affidavit.
Yes, Lordship.
Have you filed your affidavit?
No, Lordship. In one similar matter, we have sent for vetting, Lordship. That
We
will
are not bothered about similar matter. We are talking about this PIL.
Lordship, in this, we have not filed. Sometime may be granted.
That's what we want to hear.
Sometime may be granted.
You are appearing for the
Social justice.
an empowerment department. What, Mr.
Yes, they, my lord.
Is deal and counsel for the petitioner. Mr.
C. Sharma, Lordship.
C. Sharma, the next standing counsel, Social Justice and Empowerment Department. Praise for how much time?
Lordship, 2 weeks.
Praise for 2 weeks time to file affidavit in opposition.
Lordship,
Praise.
this matter may be tagged with the others.
The others are slightly different, my lord, because
We'll see after you file your affidavit, list after 2 weeks.
lordship, can it kindly be fixed on a particular date, my lord? Can it be 19th?
19th will be a little difficult, so stop. List on 29th.
My lord. Obliged, my lord.
Item 12.
May it please, your lord. My lord, as per the last order, my lord, the chief engineer was directed, my lord, file affidavit. Lordship,
2 weeks time may be given as instructed by my.
in that case, my lord, a date may be fixed.
Or
We have
Mr. B. Baral and counsel for the petitions. Mr.
N. Kolita.
N. Kolita, Leonard, Government Advocate,
No, on behalf of DNAT, Lordship.
Leonard Counsel appearing on behalf of Mr. D. Nath, Leonard Senior Government Advocate. Praise for how much time?
2 weeks time. Lordship.
2 weeks time. Appearing on behalf of respond number 5, huh? Praise for 2 weeks time to file affidavit. Praise the Lord. List on 29th.
obliged.
Item 13.
May I please, the lordship.
Yes.
Lordship, in this case, lordship, I just point out lordship, whole fact, lordship. Lordship, here in the year 2005, a land acquisition case was initiated, lordship. In the year 2008, the award is prepared and approved, and ultimately, lordship, in the year 2013, notice was issued to the peasant appellant to directed lordship to receive this awarded compensation.
Quarterly, have you found out the act?
Yes, yes, your lordship. Lordship, I have. Lordship, the point number 6, it is stated, the LA estimate for acquisition of land for construction of the composite check gate was prepared as per the LA Act of 1894 instead of the land acquisition, the LARR Act of 2013. And accordingly, payment made to the concerned landowners after deducting the required TDS 10% towards the land acquisition compensation amount as per the government instructions and the guidelines. All the annexures are included in that batch of papers, your lordship. So if they file their returns, they will get the refund of that 10% which has been deducted as TDS. As simple as that, your lordship. Lordship may close this case, your lordship.
Lordship, lordship, just I point out one thing, lordship. That lordship, section 24 of this new act, 2013 act, lordship.
You were paid the land compensation
Yes.
under the LA Act of 1894,
Yes,
Yes.
lordship.
not
That's
2013.
Yes.
lordship. That's I'm saying that point, lordship. Lordship, 2013 act, section 24 is saying, lordship, under certain circumstances, the land acquisition proceeding of earlier act, it's deemed to lapse, lordship.
Give us the act.
নাপায় বুলি কৈছে সি নাপায় বুলি কৈছে মই 3 years ইনকাম টেক্স ৰিটাৰ্ণ ফাইল থাকিব লাগিব তেতিয়াহে পাব নাই
It is their fault. It is not fault.
Yes, section 6.
Lordship, here Lordship, the first or second point in Lordship, I am not saying Lordships. The second clause say to Lordship, nothing withstanding anything contained in subsection 1. In case of land acquisitions proceeding initiated under the Land Acquisition Act 1894, where an award under the said sections 11 has been made 5 years or more prior to the commencement of this act, but the physical possessions of this land has not been taken, or the compensations, Lordship, this is important, compensations has not been paid, the said proceeding shall be deemed to have lapsed.
Compensation, you did not get your compensation.
No, Lordship.
Lordship, they are being paid
Lordship,
14 lakhs 57,124.
Lordship, that amount has been paid on Lordship 30/10/2023. Lordship, that's why Lordship, why they have not had made payment, Lordship, in their affidavit, it is reflected, Lordship, since 2009, one and another writ appeal or writ petition is filed before this honorable court, and this honorable court has granted an stay. That's why, Lordship, that amount has not been released. So,
In a case, you have been paid your compensation, isn't it?
Lordship, in this case, Lordship, I am claiming only for Zirat compensation, not land other compensation. As because here our appellant is not landowner, Lordship. He is
This
only the
government land, your Lordship. So they had been
So
paid
you,
Zirat
so you've been
compensation.
paid your Zirat compensation.
Zirat compensation.
You've
so
been
Lordship.
paid.
Yes, Lordship.
Then how
Then
will this apply?
Lordship, the paid Lordship on 30/10/2023, Lordship.
Hmm.
That's why, Lordship, I am saying, Lordship, in this 2013 Act, it's covered, Lordship. Then, Lordship, 96 sections, it's saying, Lordship, the tax liability is not there. So, Lordship, here appellant is claiming, Lordship, just only for tax benefit, Lordship.
Lordship, may kindly come to point number 3. The documents which I have furnished, your Lordship, it is written. Point number 3. The TDS amount had been deducted towards the compensation amount for land acquisition purpose. As per the Government of Assam Revenue and DM LR Department letter, such and such dated 30th of April 2011, that is annexion number 2. Lordship would kindly come to annexion number 2, your Lordship. This subject, applicability of income tax towards compensation received by the landowners for the land acquired under the Land Acquisition Act and other rehabilitation grants as well. Lordship, the subject. With reference to the subject cited above, I am directed to forward herewith a photocopy of the circular under reference received from the Director, Land Reforms, Government of India, Ministry of Rural Development, Department of Land Resources, Land Reforms Division, New Delhi, which will speak for itself, and to request you to kindly take necessary actions accordingly. Lordship, the circular is the immediate next page.
Yes.
This is the subject, this is dated 13th of April 2011. The subject is applicability of income tax towards compensation received by the landowners for the land acquired under the Land Acquisition Act and other rehabilitation grants as well. Sir, I am directed to say that the government is giving special attention to the issue of people getting displaced on account of development projects and therefore has been contemplating to amend the Land Acquisition Act 1894 and also bring up rehabilitation and resettlement statute. The However, it has been brought to the notice that the people who are getting compensation are getting charged towards income tax and TDS of 10.3% is being deducted from the source. It appears that the LA collectors are often not fully aware of details of taxation laws and erroneously subject landowners who have their land acquired to taxation they are exempted from. Number two, this department had taken up the matter on the issue of tax being collected on the compensation awarded under the Land Acquisition Act with the Department of Revenue, Ministry of Finance, and Government of India. The Revenue Department, Ministry of Finance have explained the provisions of Income Tax Act 1961 in this regard with respect to land acquisition compensation as under. All the transfers of the land, including the compulsory acquisition of land, come under one category only, that is land transfer. Land are categorized into two categories, agricultural and non-agricultural lands. Agricultural lands are further subdivided into two categories, that is rural and urban. Urban agricultural lands are those agricultural lands which are situated within the limits of municipality or at the notified distance of maximum 8 kilometers radius of their boundaries. There is no tax liability on the transfer of rural agricultural land. This particular plot of land is a VGR land. This is a government land, Your Lordship, not an agriculture. Number four, the income by the way of capital gain arising to an individual or a Hindu undivided family or compulsory acquisition of an urban agricultural land is exempt from taxation after the first day of April 2004, subject to the following conditions. So these are the conditions for the Hindu family. Point number 5. On the transfer of urban agricultural land, other than that mentioned in para 4 above, capital gain tax is levied. However, no tax is deducted at the source on transfer of urban agricultural lands. Owner of urban agricultural land in these cases can take benefits available under the following provisions to reduce the tax liability. This is regarding the urban agricultural land, Your Lordship. Then point number 6. Capital gain tax is to be paid if none of the above options are exercised. However, taxation will be based on gain on indexed amount of original cost of the asset in the cases where the asset has been held for a period of 3 years more immediately preceding the date of transfer. Point 7. The transfer of non-agricultural lands is liable for taxation. Our case falls within this category, Lorships. However, as per the provisions of Section 194 LA of the Act, there is no applicability of tax deduction at source in cases where the consideration received is less than 1 lakh. However, if the consideration received is more than 1 lakh, tax at the rate of 10% is deducted as TDS. So according to this category, the 10% has been deducted in the present case.
Lordship, my
Point
submission.
number 8, the owners of the non-agricultural land can also avail the reliefs shown at para number 5.1 and 3 in the case of transfer of non-agricultural land. Further, a project affected person can make an application under Section 197 of the Act to his assessing officer and obtain a certificate for lower rate of deduction or no deduction in the appropriate cases. You are accordingly requested to kindly see the matter as above are brought into notice of all the officers connected with land acquisition and inform them as to take adequate care so as not to put the farmers and other landowners into unnecessary taxation if they are exempt from it as per above clarification of the Department of Revenue, Ministry of Finance, Government of India. This is by the DLR, Your Lordship. Signed by the DLR. So this present case falls under category 7, which I have read out.
Lordship, my submission is that, Lordship, once Lordship land acquisition proceeding is less of earlier act, Lordship, then Lordships subsequently the new act comes. And if new act comes, Lordship, then section 97, it clearly says, Lordship, no tax liability. Lordship, I just.
That we know.
Lordship. So, Lordship, so my submission is that.
The only problem that
Lordship. My Lordship, section 24, Lordship, subsection 2. Here already clearly mentions Lordship. If Lordship, land acquisitions.
There are three parts here,
Yes,
isn't it?
yes, Lordship.
First part says notwithstanding anything contained in subsection 1.
Good.
Case of land acquisition proceedings initiated under the Land Acquisition Act 1894.
Yeah.
Where an award under section 11 has been made 5 years.
Yes,
Or more
or more.
prior to the commencement.
Yes.
of this act. This one part.
Yes, Lord.
Now, when was it initiated?
Lordship, the next line, Lordship.
When was it initiated?
Lordship, it is initiated, Lordship, in the year 2005. And award, Lordship. Award has been passed in the year 2008.
Right.
2008, Lordship, in their affidavit in opposition is reflected, Lordship.
Now what?
In the year 2008, Lordship.
Lordship, in the affidavit in opposition, page 60, paragraph 8. Paragraph 8. May I read it? On completion of required formalities as per provisions of the LA Act 1894, including approval of award by the government and revenue and DM department, the expectation to issue notices to the landowners for handing over possession of the acquired land in December 2008. But due to interim order of the Honorable Guwahati High Court dated 6/2/2009 in writ petition such and such, the process was kept in abeyance. Subsequently, on final disposal of the writ appeal by the Honorable High Court, wide order dated 3/11/2011, the process was reinitiated after completion of the order, direction of the Honorable High Court. Accordingly, the date was fixed for taking over possession of the acquired land with effect 18 February 2013, and notices for handing over possession of the land were issued. While the process for taking over of acquired land was going on, another writ appeal was filed by the legal heirs of the writ petitioner of writ petition such and such. The Honorable High Court passed interim order dated 22 February 2013 in the above noted case to maintain status quo in respect of the land of the writ petitions. The said writ appeal was vacated by the Honorable Guwahati High Court by its final order dated 2nd of April 2013. It is worthwhile to submit here that the subject matter of the instant writ appeal is almost similar and identical to the other two earlier writ appeals stated above, and the Honorable High Court was pleased to dismiss both the writ petitions. Subsequently, on final disposal of the writ petitions as stated above, the process of taking over land has since been completed and handed over to the representative of the requiring department, and payment of compensation and the process of payment is underway after observing required formalities. The LA estimated fund provided by the requiring department was kept in the revenue deposit under head of account such and such, despite of another writ appeal numbered such and such, and the process for release of the compensation money and Zirat value was kept in pending. As per order, the Honorable High Court dated 1/11/2018, the payment process of the acquired land and Zirat are underway. That's why the delay happened here, because there were several rounds of litigation filed by.
Lordship, in page 25 of my read memo, Lordship, here, Lordship, it is reflected. Lordship, award was prepared on 25/2/2008.
When will you admit it? Okay, heard Mr. Ihaq, Learned Counsel for the admit. Oh no, heard Mr. Ihaq, Learned Counsel for Dublin, also heard MSN Bordole, Learned Standing Counsel, Revenue Department. Admit. List the matter for hearing on first week of February
For final disposal.
for final disposal.
Lordship, they can file the tax returns, your Lordship.
Yeah, otherwise you can find your tax return.
Lordship.
What is the difficulty?
I think they don't have the tax file.
Lordship, as per my instructions, Lordship, TDS will be take return back on the basis of when on a person's having a minimum 3 years income return file, Lordship.
6th February.
So it is their fault, your lordship. They have not filed their returns timely.
Highly offensive.
Item 14.
Wait, please, a second. My Lord, we had approached the single judge against a direction passed by the Deputy Commissioner to strike out our names from the land record. My Lord, may I place the background very quickly, my Lord? My Lord, our ancestors, my Lord, were recorded owners of a huge parcel of land measuring nearly about 101 bighas, my Lord. My father was one among those recorded owners, or a pattadar. Now, what had happened was we had inducted agricultural tenants into the land. Now, your lordship is aware that agricultural tenants have a right under the Act of 71 to acquire the ownership right. Now, while applying for ownership right, they're supposed to issue notices to the recorded owners. Then the state calculates the compensation and eventually it is settled with the agricultural tenants. Now, here in this case, these agricultural tenants had initiated that proceeding, but they had served notices on a few dead pattadar who were already dead by then. So one of the co-pattadar owners, they challenged this entire process of acquisition by the tenants or the riots as they are called before the Board of Revenue. I was not a party to the Board of Revenue. Now that judgment of the Board of Revenue, your lordship finds at page 35, annexure 2.
Yes.
Now, this, your lordship will remark, was initiated by one Dipendranath Goswami. He was one of the co-pattadars or the co-owners of that particular land. Now, the Revenue Board examined the matter and eventually came to a finding that the entire process of bestowing ownership rights on the tenant was not proper since the pattadars were not served with the notices. That, Your Honor, your lordship finds at page 40 of that judgment. Internal page 6, the last paragraph. It begins with after perusal of the relevant record.
Yes.
After perusal of all the relevant records and hearing of the learned advocates, it is seen that TR case number so-and-so was instituted against persons who were dead and their legal heirs were not impleaded in that case. Order cannot be passed against a dead person without impleading his or her legal heir. So far as the question of ADC Hodor to dispose of such case is concerned, it is clear from Government of Assam's notification dated so-and-so, it is seen that the additional deputy commissioners and subdivisional officers, including the subdivisional officers Hodor, have the power of the revenue officers for the purpose of the Assam Temporary Settled Areas Tenancy Act, and these officers will also have the powers of the deputy commissioner until further order. Therefore, it is correct to say that the SDO does not have power to dispose of against this appeal has been filed. So it was eventually held that these proceedings were against a dead person. So therefore, this acquisition by the tenants of ownership right was wrong. Till there, it was fine because we were also the recorded owners. But here in this judgment, an observation was made, which your lordship finds on the following page. Page 41. From the chitta of the suit line available in the case record, it is seen that the patta of the land is Niskhiraj Patta, Niskhiraj Patta or half revenue paying estates, originally from the land given by the Ahom kings, which later came to be Dharmottor, Debottor and Brahmottor. Therefore, it cannot be disputed now that the land is not Hotro land. The proviso to section 15A of the Assam State Acquisitions belonging to religious or charitable institutions of public nature, as amended, states that notwithstanding anything contained in the Assam Land on Revenue Regulation, the right of transfer of land belonging to the above mentioned institutions for a riot shall only be to a person belonging to same religion in which the ownership of the land was vested. Hence, it is seen that the so-called tenant were given ownership rights by the SDO Borbota belonging to another religion. So the order giving ownership rights to the tenants was faulted on two grounds. Number one, that the original pattadars were not served. They were already dead by then. And second, that the settlement was made in favor of tenants who were from another faith, which is not permissible. Now, because of this observation that was made that it could be a Hotro land, as in belonging to a religious institution, taking a cue from this, the deputy commissioner initiated another sort of exercise to cancel the entire patta from the name of the recorded pattadars and to incorporate it in the name of the Hotra. That your lordship finds at page 43. Now, though the judgment was otherwise in favor of the pattadars, because of that observation, the deputy commissioner said that, oh, this probably could be Hotra land and therefore the entire records need to be corrected. Page 43. With reference to the subject cited above, I have the honor to inform you that the land measuring 101 bigha so-and-so, covered by so-and-so, is recorded in the name of 5 pattadars. My father's name is at serial number 5, Haranidhar Goswami. That now it says, second paragraph, that though there is no mention of any Hotra land called Pirola Hotra in the Chitta on Rayati Khatian available in the office, however, as per the judgment order of the Honorable Court of Assam Board of Revenue, dated so-and-so, it is mentioned that it cannot be disputed that the said Niskhiraj Patta land is not a Hotra land, from which it can be construed that land is a Hotra land. In this regard, the demarcation of the boundary so-and-so, then the last paragraph, if I may skip over to that. Therefore, sir, it is humbly requested to give necessary instruction on updation of land record Chitta by incorporating the name of Pirola Hotra and also regarding striking out of the names of the riots from the revenue records. Now, accordingly, this was on the following page forwarded to the circle officer with the direction from the deputy commissioner that your lordship finds at page 44. I'll just read the second paragraph. Further, the land records is to be corrected as the provisions of the Act, the Assam State acquisitions of land belonging to religious or charitable institutions of public nature. After correction of the land records, the same may be intimated to the undersigned. Now, my lord, we were originally figuring, as at least my predecessors were figuring as owners of that land. The dispute was between one of the co-owner or a co-pattadar and the agricultural tenants, where he said that these agricultural tenants cannot acquire ownership rights. Now that judgment was passed in favor of the landowner, but because of that passing observation, the entire records are sought to be corrected. And I was not even privy to those proceedings. I merely happened to be a co-pattadar, and sort of a collateral damage on me, my name is also sought to be struck out, and they're trying to incorporate it in the name of a religious institution or Pirola Hotra as they call it. Now, we approached the learned single judge, and in fact, your lordship has already seen that the deputy commissioner was also not certain or sure about the fact that there existed a Hotra called Pirola Hotra. Nevertheless, they chose to correct the records only on the basis of that observation made before the revenue board. Now, at page 165 of the judgment by the learned single judge, just one clarification additionally, my lord, that though that revenue proceeding was concerning only 17 bighas out of this 101 bighas. Now the entire 101 bighas is sought to be corrected. Now, paragraph 9 at page 165, the learned advocate general fairly submits that though initially there was indeed some doubt on the existence of the said Hotra, which finds mention in the communication dated so-and-so, after thorough investigation, a specific conclusion was arrived at, which was communicated by letter dated so-and-so, regarding the existence of the Hotra, which was said to be wholly or under illegal occupation of persons of doubtful citizenship. The learned advocate general further submits that while communication dated so-and-so is the subject matter of challenge, the basis of the said communication, namely the judgment dated 18/7/2005 of the learned Assam Board of Revenue, is not challenged, and therefore the petition itself is not maintainable. He further submits that the impugned order dated so-and-so, the correction passed by the correction in the land records were already done on 6/5/22, and the interim order was passed as of the subsequent date, which did not have any effect. There is no further action seen from the side of the petitioner in either filing a subsequent petition. Now, if your lordship may now turn to paragraph 13, that is where the moot issue is discussed. The primary stand of the writ petitioner is that there is no Hotra in the name of Pirola, which was existing, and to substantiate the same, a communication dated so-and-so was pressed into service. The aforesaid communication dated 8/7/2019 was passed by the circle officer Chenga Revenue Circle on the subject of the status of the report of the Hotra land. Though it is a fact that only 2 hotros have been mentioned in the said report, the subsequent communication gives no manner of doubt regarding the existence of a Pirola hotro and also the fact that the same is under illegal occupation. Those Sri Kotoki learned counsel for the petitioner may be correct in stating that without giving him an opportunity, the subsequent material should not be taken into consideration. The materials placed on record are on public domain and cannot be construed as something which this court cannot take judicial notice of. However, even ignoring the contents of the said reports placed on record, the court finds the existence of hotro in other contemporaneous documents. Further, while it is intriguing, what is intriguing is that while the order dated 11/4/22 has been challenged on the basis of the said order, which is the judgment dated 18/7/2005 passed by the learned Assam Board of Revenue, has not been challenged in any manner. There is not even a passing reference that the petitioner is aggrieved by the said judgment of the learned ABR. Now, my prayer was quoted, and at paragraph 14, it was held that without there being a specific challenge to the basis of the impugned order dated 11/4/22, this court is not even required to look into the other aspects of the matter. The court also finds force in the submission made by the learned Advocate General that the order dated so-and-so was already acted upon and the correction made on 6/5/22 and the subsequent action has not been put to challenge. The question in which the state has raised doubting the bona fide of the petitioner in instituting the present case in absence of a specific denial is also a relevant factor which the court has considered. On a specific query, learned counsel for the petitioner has submitted that the petitioner is a teacher and therefore by no means can be assumed to be personally cultivating the land in question, wherein the provisions of Article 31A might come in. In any case, the said protection is only in the matter of acquisition of land and not for making the land encroachment free, and therefore the recourse to the constitutional provision is not at all applicable in the instant case. This court also finds force in the argument of the learned Advocate General that the Act of 1959 provides for an appeal, and in case the petitioner was aggrieved by any provision of the Act, he can prefer an appeal under Section 21(3). So the basic ground for dismissal is that I did not challenge the judgment of the Assam Board of Revenue, where a passing remark was made that it could be a hotro land. Now, to that, my answer precisely would be, my lord, first of all, I'm not even a party to those proceedings. So any declaration or any order passed therein would naturally not bind me. And secondly, my lord, that judgment, even if I'm held to be on the same footing as the other co-pattadars, then also the judgment was in our favor. It is only the finding that it is only that particular finding which may sort of create a cloud on my title.
That observation.
That observation. Now,
That observation you should have challenged.
my lord, to that, I would say, my lord, I could not have challenged because these revenue proceedings follow the normal civil procedure code, and under that code, there cannot be an appeal only against the finding. There has to be a decision against me, as in a final judgment or a decree against me, so as to for me to avail the remedy of an appeal. And an appeal will not lie only against a mere finding, if the otherwise the outcome is in my favor. Now that is of course a principle I seek to borrow from the civil law, but that even revenue proceedings are governed by the CPC, and therefore I could not, first of all, I could not have, because it is a mere finding, and secondly, I need not have because the outcome has gone in my favor, and thirdly, that judgment doesn't even bind me because I'm not even a party to those proceedings. Now, my lord, apart from this, my lord, Deputy Commissioner otherwise has a power to correct the revenue records if he receives information. Now, that power stems out of a particular provision, which is 53A of the regulation. But given the
Has it been corrected?
It has been corrected, which is why I'm not praying for a stay at this moment, my lord. If the order is eventually set aside, my lord, then we may go for a.
Yes.
Now, 53A of the Assam Land and Revenue Regulation, my lord.
Then revenue manual.
The regulation is there at, my lord, has the same book, then probably it's page 24.
Yes.
53A, my lord.
Oh,
Power of Deputy Commissioner to direct registration on information received otherwise than through application. So normally corrections are done on the basis of applications, but this is a unique power. Notwithstanding anything contained in section 50 to 53, where the Deputy Commissioner has received information otherwise than through an application of any taking of possession or assumption of charge as is referred to in section 50, he may make an order directing registration of the name of the person so taking possession or assuming charge, provided that the information has been verified by local inquiry made by an officer not below the rank of the assistant settlement officer, or B, notice has been published and inquiry has been held in the manner prescribed under 52 and 53 as if an application for registration has been received from the person to whom the information relates. Now, if your lordship may take up the previous two sections, 52 provides for, on receiving an application under section 50 or section 51, the Deputy Commissioner shall, if he considers that there are sufficient grounds for proceeding with the application, publish a notice requiring all persons who object to the registration of the name of the applicant or who dispute the nature or extent of interest in respect of which registration is applied, have in a written statement of their objection, appear on a day to be specified in the notice, not being less than 1 month from the date thereof. Now, these provisions, my lord, conceive of a thorough proceeding where interested parties have to be put to notice. Now, your lordship will see the arbitrariness here. There is some judgment in a revenue proceedings where I'm not even a party. Based on a observation made in that judgment, the revenue records are sought to be corrected and I'm not even put to notice, my lord. No, there are other aspects which perhaps will require a hearing because there was even the Board of Revenue. It assumed that this would be a Hotro land because the classification was shown as Niskiraj. Now, Niskiraj colloquially probably means half revenue, and it was originally given for religious purposes. But that has changed through the years, and in fact, the Supreme Court has traced the history of how it began and how it ended. And eventually, since I'm there, as recorded pattadars today, my lord, my rights are that of a landholder, my lord. Those are areas perhaps your lordship will have to consider. For now, if I may just pray for an admission.
You put the correction on challenge.
My lord, the correction was just a ministerial act which had followed from the order of the Deputy Commissioner, which is under challenge.
Yes, Lordship. This is a very pertinent issue because after the 11th April's order, it was corrected in the month of May. He got the opportunity to challenge that. It was never challenged. And on top of that, this last ground, which he has taken, that 53A of the Assam Land Revenue Regulations 19, that was not a pleaded case before the learned single judge. It's a new ground, they are taking it now. There is absolutely no infirmity in the order passed by the learned single judge. And on top of that, Lordship, one paragraph, page 166. Paragraph 10. That was not read by my learned friend. The learned so-and-so has also placed before this court an additional affidavit dated 9/1/2023, wherein the excerpts of the interim report of the Assam State Commission for Review and Assessment of Problems of Potro Lands in Assam dated 29/10/2022, as well as the final report dated 30/12/2017 by the Committee for Protection of Land Rights of Indigenous People of Assam has been put on record. On perusal of the records, the existence of Pirola Potro and the fact that the same is under illegal occupation clearly comes out. These were the reports we placed, and they are part of the record now. In the appeal also, they have annexed the relevant portion. So from all the attending facts, it is abundantly clear that, Lordship, that particular area is enclosed by some persons who are not belonging to the same faith. Number two, it was a Satra. That declaration was given whether it is in respect of one of the pattadars or in respect of 5 of the pattadars of the same parcel of land, 101 bighas. It will be equally applicable for all pattadars because the whole land was put to question. It was encroached by some persons who are doing agricultural lordship, and they are not before this honorable court in these proceedings. So in my humble submission, the grounds on the basis of which the writ petition was dismissed were totally acceptable grounds. There is no infirmity, no arbitrariness.
We'll have to examine the matter. We'll admit this.
Lordship, in my humble son, Lordship, may be pleased to dismiss the petition without admitting. Because abundantly they have failed. Till now, they have not failed to make out a prima facie
There are
case.
some areas where we want to see the matter.
Then a very short date may be given, Lordship.
But Mr.
BD Deckham.
Also for that. Also heard Mr. D. Saikin and the Advocate General Assam. For the response.
Because this has a public interest in all over Assam, Lordship, about 10
No, we are not passing any stay order.
I understand, Lordship. That is why a short date may be given.
Admit this the matter for hearing. When do you want?
Maybe on 23rd. 23rd or 25th. 25th, let it be on 25th of.
25th.
Observations may be given that the attempt may be made to dispose of the matter, Lordship. That observation.
Attempt shall be made to dispose of this writ appeal on the next return.
Highly obliged, Lordship.
Lordship, this has been duly received by the petitioner, Lordship. I have the copy. And in the document that I have submitted in the morning, Lordship, in the first page also, in the signature column, his name is there, Lordship.
But the dues amount of
So
from the month.
this type of wrong submission, Lordship, this should be, Lordship, noted.
You've received it.
My lord, I'll again confirm, my lord. Yesterday I talked with him. He said that he didn't receive. If suppose there,
Signatures are there, his name is there.
if I get the copy, Lordship, I can confirm.
You have an extra copy?
Lordship, I have.
I will take a
get
photo
it,
copy,
Lord.
my lord. My lord, the dues are from the month of October, my lord.
He confirm, Lordship, or else.
October 2023. November 2023. December 2023, you have received.
My lord, the question doesn't tell, my lord, because that point of time, my lord, so far the current dues are concerned, my lord. The current dues are concerned, my lord, because that's the last occasion they themselves submitted that within 1 week they will release the amount, my lord.
So that's what they've released the
My
amount.
lord, I will make that clear, my lord.
But Mr. Samarian is also for the appellant. MSM Bhattacharya, learned. Standing counsel.
Yes, Lordship, for the
Appealing on behalf of the Golbara Municipal Board submits that the petitioner has been paid the
current pension.
Current
yes, Lord.
pension.
with effect from October 2023 up to December 2023.
Lord.
Stop. To that effect, comma, she has produced documents which indicates that the petitioner has that the appellant has received the said pension amount. Stop. For Mr. Samarian and the counsel for the petition appellant press for some time to verify as to whether the appellant has received the pension amounts for the period October 2023 to December 2023.
I will collect that
List
copy of
down. When do you want?
after 4 weeks, man.
Why 4 weeks?
My lord, otherwise reopening, my lord.
24th
My lord.
January.
Lordship, can it be on 25th, Lordship?
25th.
My lord.
Deeply obliged.
Who's that lady?
In this case, Lordship, the state respondent supposed to file affidavit, because I have taken step as per the order dated 15/11/23. It is, the matter is about the dismissal of service.
Yes.
My lord, affidavit is ready to file.
No, no, what affidavit? It's a writ appeal, isn't it?
Writ appeal, yes.
Yeah.
In fact, in any case, if to file, then we'll file it, no problem.
What's the
The
necessity?
removal from service.
What's the necessity to file an affidavit in a writ appeal?
If then lordship and may fix another date, I'll, in fact,
Okay.
but today I am not ready for submission.
Okay, on request made by Abhijit Mazumdar, learning counsel for the appellant. When do you want
Any date, lordship, as per convenience of the court,
this on 29th?
lordship.
Obliged.
Item 37 and 38 are connected.
Hmm.
May I request your lordship to pick up the file of 38 because the pleadings are completed. I mean, it's a later date petition before the learned single judge. So
Yes, sir.
affidavits filed over there would be part of the record. And there are material findings on the basis of that. affidavit. Item 38 file may be taken.
Lordship, only before one thing I may point out to you, Lordship. Here some new documents has been brought in by the appellant, which were not a part of the records earlier, and they are absolutely illegible. Absolutely illegible.
Page?
What are the pages? You're referring to?
I think pages I'm referring to the agreements which you have annexed. Page 30, 29, I think 29 onwards. That
Page
is my copy.
29 of item number
38.
38.
38.
I'm actually not, it's a concession agreement. We are not relying really on that at all. It's just for the
They
purpose.
don't rely on that, it's fair.
I'm not relying on it. We'll file a better copy, but I'm certainly not, it's not part of the.
So whether you rely upon it or does not rely upon
I,
it, you are supposed to file
in
a
fact, even my
legal
copy was, not very clear.
Not legible. I mean, I don't know whether he relies
No,
on
we
it.
are not relying on it. No? If your lordships may take it because this matter is some
Why
important.
did you type it out and give it?
They should have done it. But we'll give it to them. But for the purposes today,
I don't know about the court copy. What is the court copy like?
Court's copy, somehow we can read it.
we'll give it to them today itself.
Page 30, isn't it?
Yes.
Yes, 27 onwards, I think.
27.
27. So you're right. Lottery starts from 27 onwards.
27 onwards. I agree.
After 30, it gets. After 32, it gets blurry.
But we are not really relying on it at all. I will forgive a call. We will have my, I'll ask my instructor.
Page 40.
And these documents never form the part of the writ petition.
You'll have to file a type copy.
We'll give it to them today itself. But
Even us. Even the court.
even your lordships, I think we can have it done. Then could your lordships have it on Monday because there's some urgency in the matter.
Let it on Monday.
Okay.
Fine.
What, Mr.? What's his name? You Hazarika. Then it's senior counsel. For the appellant as well as Ms. M. Hazarika. Then it's senior counsel appellant for the respondents.
For the respondent number one and two. You put
For respondent 1 and Mr. Arkade F. Chaudhary. Then it's ASGI. For the ESGI for the respondent 2 and 3. Is the matter. You know. When do you want?
I'm great.
Monday?
Thank you. No, Monday, coming Monday.
Eight.
This coming Monday.
8.
I'm great.
Monday.
An application for condonation of delay in preparing the writ appeal.
2017 matter.
My lord, yes, but the service of notice on the I was not completed. We have completed it through paper publication, my lord. The paper publication has come up on 17th of October 2023.
Have you filed your affidavit?
My lord, yes, the affidavits have been filed, my lord. কি হয়?
It will have to be a legal notice.
Paper valuation
It will have to be a legal notice.
Yes, paper valuation notification করছে। No, affidavit. Thank you.
These are the respondents.
My lord. Now, all the respondents, my lord, few of them have expired, and for the others, my lord,
I'm appearing for few of them, my lord. I'm appearing for 1, 2, 3, 8, 9, 10, 11, 14, 15, 17, 21, and 22, my lord.
How many days?
my lord, the delay was of 1,186 days from the date of the orders passed in the writ petition. Thereafter, we had preferred a review petition, my lord,
Okay.
and some time was consumed in, my lord, having the review petition disposed of. On the date of disposal of the review petition, my lord, the delay is around 300 days.
300 days.
This
Do you
will
have
get-
any objections?
My lord, only one thing is that, my lord, review was dismissed on 39/15, my lord, and instruction to file appeal was given on 17/5/16. This one, almost, my lord, 10, 12 months delay has not been extended. Now, this, I am leaving to lordship.
Otherwise, my lord, the issue which is involved, my lord,
You are praying for which respondents?
I am praying for, my lord, 1, 2, 3.
1 minute, 1 minute.
ডিসকাউন্ট আছে নেকি শুনছো টাকা কেন এপিএ করেছি
You've done the paper publication only
yes,
for
sir. It is-
respondent 5, 6, 12, 18 and 19. correct?
Yes, my lord. It was done on 4/12/2023, my lord. On 17 October 2023, and on 4/12/2023.
Hmm?
Order 23 to paper publication के लिए photo take it.
Are you appearing on any of these respondents?
No, my lord, I am
Where
appearing,
paper publication was made?
no, my lord, I am appearing for, file wakalatnama for 1, 2, 3, my lord, then 8, 9, 10, 11. Then, my lord, 14, 15, 17. Then, my lord, 21 and 22.
তোমার মরিশিলের উপর লিখে লইছো
Let us give them 1 week time if they want to make something here. After that, we'll dispose of it. But Mr. R. Majumdar, the standing counsel. School Education,
Department of School Education.
Department of School Education for the applicant. Stop. We have perused the affidavit. Dated 9th November 2023. Whereby the paper publication for service of notice to the respondents 5, 6, 12, 16, 18 and 19 have been annexed. Stop. On consideration of the same, the affidavit is accepted. Accordingly, the notice on the aforesaid respondents shall be deemed to be complete. However, as none appears for the aforesaid respondents, list the matter again on when.
Any convenience of
Or let us give them 2 weeks. 2 weeks. The 24th. Yeah.
I'm obliged.
17.
But in this matter, my lord, I pray further 2 weeks time to file the reply. My lord, here the issue of delay in issuance of payslip of the judicial officers is involved, my lord. Some, my lord.
Lordship, in this case, I have something, your lordship. Kindly peruse the prayer of the miscellaneous application, page 11, my lord. Prayer number one is Lordship issue direction to revive release WBC Sumoto that already been released, my lord. Second prayer, my lord, direct the respondent to issue all necessary, Lordship. Miss case 18/2020, my lord.
Yes.
Well,
Lordship,
why my
prayer
brother
number-
is pressing, I don't know, my lord, since I am yet to file my reply in this matter. He perhaps wants to say that this case has become infructuous, but there are still problems, my lord. We wanted an independent portal which all the judicial officers can individually access and get their payslip, leave statements copies. Now, what they have done something, Miller. What they have done, they have integrated the AG office, Miller, details with the FinAssam portal, and FinAssam portal can be opened only by the DDOs. Now, if a judicial officer, Miller, judicial magistrate grade 3 wants to have his payslip, he has to write to the district judge, learned district judge, and accordingly he'll open and get. So there are problems that those things I just want to bring it to you before your lordships, nothing else. Otherwise,
Mr. S.K. Das, Learned Council, Standing Council, Guwahati High Court. Praise for another
2 weeks time, my lord.
2 weeks time to file reply to the affidavit filed by the Senior Deputy Accountant General. with
Yes, ma'am.
Admin.
Lordship,
Praise
that may be
the Lord.
fixed, my lord. That may be.
Please start 2 weeks. 29th January.
Deeply obliged.
Item 19, 20 and 21. You want to take a break? You want to? You can take a break. Or after this. Right.
May it please your lord. I'm the respondent number 6 in private respondent number 6 in the read appeal, and the read petitioner in the petitioner in the read petition, your lordship. I've copied, last time I had informed this honorable guy, for the last 7 months, I haven't received a copy, but now I have received a copy, your lordship. That at your convenience, let the matter be placed for, I think, pleadings are, I think. I'll read up.
May I please, your lordship? Lordship, kindly see page number 118 of the read appeal, your lordship. The review petition, and we have duly served.
I received a copy.
Yes, receive a
I
copy.
have
We have
already
du-
informed.
Duly served the copy. Your
I
lordship.
have informed.
You have received a copy of read appeal as well as the review.
Read appeal, review and read appeal and review both, and other annexes.
And this IA?
Yes, I think I have received, your lordship. IA number 2429, your lordship.
Yeah.
Yes, I have received.
So what do you want today?
Take- Allow me a date for this one, your lordship. I've yet to peruse. I'll be
Okay.
ready.
What, Mr.?
Assure, your lordship.
Yes, to Learned Council for the applicants. Stop. On request made by A. Narzari.
Yes, sir.
Learned Council for the respond number 6
Your respondent number can read
of
petition.
public read petitioner. List the matter after
2 weeks, your lordship.
2 weeks.
My lord.
Hello.
Just 5 minutes.
Therefore, my lord, your lordship can say or observe that I am not pressing it. But my lord, in terms of the amendment made into 107, section 107, the applicants will be at liberty to approach the authorities concerned. And they will consider it in accordance with law within time bound frame. That your lordship can.
In the IA.
This observation may not be given because there is not even an application. We do not know whether they will file an application. Let them file an application. There is no embargo anyway.
Mr.
I'm grateful, my.
In the IA, you say, Mr. BC Das, Senior Counsel Assistant by Mr. D. Kayu. Learners Counsel for the applicant. Submits that he has instructions not to press the present IA. However, with liberty to approach the appropriate authorities in terms of Section 107 of the answer Assam Panchayat Act 1990.
As amended.
As amended. Stop. MS B. Goyal, Leonard, Senior Advocate, appears for respondent number.
I'm for the writ petition.
Another writ-
Respondent number, I'm for the.
In the IA, in the
In
IA.
the IA, my lord, I'm respondent number one and two.
For the respondent 1 and 2. IS accordingly disposed. As not pressed. IS accordingly disposed of as not pressed. With liberty as bid.
With liberty.
We are grateful, my lord.
Any orders required in the main writ petition?
My lord, that will come up for hearing, my lord.
That will come up for admission.
And my lord, in fact, my lord, if at all, my lord, I will press for stay in view of the amendment that has been come in the Assam Panchayat Act, my lord.
It will come up in this issue.
I'm grateful.
Item 24.
May it please your lordship, consider 76 days delay to preferred or writ appeal lordship. On the
Who
lordship,
appears on the other side?
lordship that 15 ID.
Where's P. Hendick?
PNID.
PNRD, PNRD. PNRD, PNRD. PNRD.
You wanted some time to file objections.
Lordship, no, they have taken the time, lordship.
No, that's why. They,
Lordship.
they took some time. P. Hendick took time.
Lordship, come to the impugn order, my.
No, we are not going to the order.
My lord, I'll just show one thing only, my lord. This
No,
is
no,
page
not-
58 of the writ appeal. It's not
We are- we
35
are-
copies. This is
We are
not
on
a-
the IA.
I understand, my lord, but the days counted for the delay, my lord. It's a certified copy. It's not a certified copy. So
If he's not interested, we'll conduct a delay. Who's appearing for respondent 1, 3, and 6?
I'm for the department, my lord.
Which department?
PNRD department. Yeah, 1, 3, and 6, I can appear, man.
Do you have any objections in the condemnation?
Lordship, I'm not aware of this matter, my lord.
Compulsory
List is not reflecting, huh?
Compulsory appointment.
We don't have any role in compassionate appointments, my lord.
Last time you wanted time to file your objections in the present IA.
76 days delay. 76 days delay.
I don't have any objection. For delay
you
on the
sure?
action, I don't have any.
Heard Mr. FZ Mazumdar, learning counsel for the applicant. Stop. By this application, the applicant is praying for continuation of 76 days delay in filing the connected data. Stop. Mr. Endas.
I'll be
No,
appearing
no,
on
Mr. Your good name, please?
2, 4, and 5, my lord.
No, no.
Oh, yes, as Dr. My lord.
S. Datta, learned counsel, appearing for the respondents.
1, 3, and 6.
6. Has no objections for continuation of the 76 days delay. Stop. How about Das?
2, 4, 5, my lord.
You have any objections?
Let it be compromised.
Similarly, Mr. N. Das, then the government advocate, appearing for respondents 2, 4, and 5, has also no objections. Stop. Para. We have considered the cost shown in the present application and we are also satisfied. And accordingly, the delay of 76 days delay, and according delay of 76 days in filing the connected read is condoned. Registry is directed to number the read appeal and list the matter in its usual course.
What's your place?
Allow the extra copies should be served. Of the read appeal, my
Oh, yes, sir.
25 and 26.
In this matter, we have to file affidavit. to tell the state. Lordship, some time may be granted.
Last time you were given time, isn't it?
Yes, Lordship. Any day next week, Lordship.
Okay. Heard. Learned counsel for the petition. For the applicant. Mr.
C. Sharma, Lord.
C. Sharma, learned standing counsel.
Lordship, I am appearing on behalf of Mr. R.M. Dutt. He is not-
Learned counsel appearing on behalf of Mr. R.M. Das, learned standing counsel, Social Justice and Empowerment Department, Government of Assam. Praise for how much time?
Lordship, 1 week.
Praise for a week's time to file affidavit. Stop. List again on 22nd January.
That is, your lordship, pertaining to the Social Justice and Empowerment Department. And so far as the detailed police report is concerned, which has been
Let the
filed.
affidavit come first. Let the affidavit come first.
No, but the police report is based on the police department and the time period what they are asking or they are seeking, your lordship. That is for Social Justice Department.
I am appearing in that case, my lord. But let both the matters be taken on over there.
That's why I'm saying on 22nd we'll consider.
27.
May it please, your Lordship. Lordship, an appeal has been preferred against the judgment dated 11/5/2023.
May please, your lordship. Lordship, our name has been not been shown in the cause list, lordship.
Well, for industries, it has been shown, and last time the senior was also there. A. Kalita sir was there.
Industry's name, her name was shown. So we don't know that today there is a matter.
Lordship, then
You are praying for
A. Kalita,
No, no.
Industries and Commerce Department.
Industries Department is
Lordship,
shown.
but our name was not shown.
my lord, but on last occasion on 19th, I have supplied them a copy.
So somehow we missed out.
MD Bora. Okay, heard Mr. J.
Singh.
General Counsel for the registry is directed to reflect the name of Mr.
A. Kalita.
A.
A. Kalita.
A. Kalita, then standing counsel Industries Department in the process. And list the matter again on when?
No, next week, my lord, before vacation.
What's your afternoon vacation?
10th.
Obliged.
28.
In this case, the delay was already condoned and thereafter for consideration of the interpreter, Lordship was pleased to direct us to take justice steps. We somehow missed it, Lordship. We are going to take it today. Let the matter come up on Wednesday next, Lordship.
Dusty.
The justice service we have to take, we are going to take it today itself.
Okay. I'll reflect your name or Mr. D. Nath's
No,
name?
my name will be reflected because my chief secretary wants me to appear.
Mr. D. Saikel and Advocate General Assam submits that due to inadvertence, the applicants have failed to take dusty service on the response number 1. Stop. He therefore submits that the applicant will be taking dusty service for service of notice on the opposite party number 1 within a period of
Within a period of 2 days, but on Monday we'll file
Yes.
the affidavit also to that
2
effect.
days. So prayers allowed. The applicant is directed to take service of notice on the opposite party number 1 by dusty service to the registry of this court within 2 days from today. Thereafter, applicant shall file an affidavit to the effect.
Matter may be listed on 10th lordship.
Tenth.
Highly obliged lordship.
29.
Well, the I is for delay of continuation of delay, Lord. Delay of 169 days, Lord. 8 days. 168 days, Lord.
Anybody?
No,
Nobody?
no, Lord. This
So
has
you have
come,
to
this
issue
has come for the first time. Yes,
Third, T. Nath Learned Council for the Learned Senior Governor
Mano.
for the applicant. Stop. Issue notice.
Well, in other similar cases, Lordship has allowed us to take dusty, Lord. We'll take dusty and let it come after the due vacation. After 2 3 weeks.
The applicant is permitted to take steps for service of notice on the opposite party number 1
1
by dusty service to the registry of this court within a period of 1 week.
1 day.
Thereafter, applicant shall file an affidavit to the effect. List after
After 3 weeks, Lord.
3 weeks.
Lordship. Follow that.
There are a number of other cases, isn't there?
Yes, yes, Lord. Altogether, 26 appeals have been filed.
And
And,
how
and
about-
now today, 30 and 31 are same, Lord.
Same order.
Same order.
Same order. 30 and 31. All opposite party number 1.
1, my Lord. Follow that.
Item 35 for hearing.
Here in this case, my lord, petitioner claiming for antedating his promotion to the post of planning officer and thereafter to the deputy, my lord, and thereafter to the post, my lord, assistant secretary here in this case. And in fact, my lord, during the pendency of the writ petition, he got promotion to the planning officer as well as to the assistant secretary. But regarding we are,
Pendency of the writ petition or pendency of the writ appeal?
sorry, writ appeal, my lord.
Okay.
For that, my lord, I have to take some instruction regarding this because I am not getting that particular promotion order.
Mr.
Yes, Chaudhary, lord.
S. Chowdhury, Learned Counsel for the appellant. Praise for how much time?
My lord, 2 weeks time, my lord.
2 weeks time to enable you to receive instruction. Praise the Lord. List after 2 weeks.
36.
I think Psyche is having some problems.
Lordship, this matter may be taken on some other day, Lordship. Esnath Lordship, he is on legs, Lordship.
Okay. On request made on behalf of Mr. S. Nath, Learned Counsel for the appellants. When do you want?
After Bihu, Lordship.
Miss Doctor, 3 weeks,
Maybe on 1st of February, if possible, Lordship. 1st of February.
1st February.
1st February.